Employers want to know whom they're really hiring for their organization, which is why they conduct background screenings of candidates. But recruiters must be cautious not to violate any of the applicant's human rights or discriminate on any grounds, especially when it comes to health or medical records. Not yet a law, Ontario's Bill 164, passing its second reading in late 2017, would prohibit discrimination against people looking for a job based on police records, genetic characteristics, immigration status, and social condition. Labor lawyers Ashley Brown and Ryan Watkins share their expertise on how to navigate the tricky waters of background screening.
Employers look at conducting a criminal background check, usually also conducting verification of the individual's work history as well as educational credentials. And we're finding that more so employers are increasingly interested in conducting a social media presence check to see what a prospective candidate's social media presence looks like or online presence looks like. And that is absolutely fine and justifiable, legal, so long as an employer is looking at information that is publicly available.
Employers have to make sure when they're hiring somebody, obviously, that the person can do the job, especially when it's concerning safety. Courts have said, and the tribunal has said, that you can't discriminate against somebody unless it's what's called a bona fide occupational requirement. You have a duty to accommodate in the sense of, is there something that the employer can do with respect to the job that would make it easier for this potential employee to do the job that wouldn't be an undue hardship for that employer.
You can absolutely access medical information. It is legal for an employer to do that, but practically speaking, it's awfully difficult to access that information for a prospective hire, in large part because the Personal Health Information Protection Act places fairly rigorous restrictions around what sort of information either a physician or other health information custodian can disclose.
I don't think right now, in terms of genetic testing with respect to employment and hiring, I don't think it's advanced now, but I could see situations in the future as health technology improves and you'll be able to see, some of those genetic markers that may be picked up at a later time. I think the government is trying to take a proactive approach at this time and to make sure there's legislation on the books for when these things become more prevalent. You want to try to eliminate some of the risk in terms of discrimination, so you always want to make that offer first and make it conditional on making sure everything comes back that's okay.
Just making a concerted effort to ensure that the information that you're asking is relevant to the role and the essential duties of that role, and that you're not asking for more information than you're legally entitled to as an employer, and that means really just focusing on any limitations and restrictions that a person might have and not their actual diagnosis.
For more videos, visit us at hrreporter.com or visit our YouTube channel, Canadian HR Reporter. Signing off, I'm Alexia Capralos.